Couple important cases for the Attorney General tonight.
The Dan York State of Mind program is brought to you in part by Lookout Rhode Island and Takeo Comfort Solutions.
Guaranteed when I take a day off, something big happens. So, not big. I mean, there's been some big things that happened in history and in my vacation career. But last Friday, the Attorney General called a impromptu press conference to announce an indictment of a political operative who has been working for so many politicians in this state for a long period of time. In this particular case, it all had to do with the saga surrounding the House Speaker and his 2016 re-election bid. We're going to ask him about that and the provocative decision by the grand jury not to make a move on anybody, including the correctional officer who drove that truck nudgingly into the protesters yesterday. Great to have you aboard. Thanks for tuning in. This is a Friday program. You know that because you're watching the show. We tape our Friday shows on Thursday afternoon. So if anything on these two stories develops between the time that we record and you see it, we'll catch up with you on Monday. So with no further ado, here's the headline that drove the news on Friday, and here's the Eyewitness News summary of the AG's press conference.
This was the mailer sent out by Republican Shauna Lawton in 2016, endorsing Democratic Speaker Nicholas Mattiello for state rep in Cranston after she lost the Republican primary in that race to Stephen Frias. Now Attorney General Peter Neronha says a grand jury has indicted former Mattiello advisor Jeff Britt, accusing him of laundering money to Lawton through a campaign donor to pay for that mailer.
Rhode Island's election laws exist for a reason: to ensure transparency in our elections. Mr. Britt, as alleged here, thwarted these goals by intentionally and unlawfully disguising the true source of the funds used to pay for Ms. Lawton's mailer endorsing Speaker Mattiello.
Here's what Speaker Mattiello told us about it in 2016.
I came to the conclusion that nobody in my campaign has any knowledge of that issue.
Britt's attorney, Robert Carenti, says, "We believe that the evidence at trial will leave Rhode Islanders scratching their heads about who did and who did not get charged, and will show that Mr. Britt was used by the Mattiello campaign as a fall guy." But a spokesperson for Mattiello's campaign says these proceedings do not involve the Speaker. The Board of Elections resolved this issue for the campaign approximately 1 year ago.
This criminal conduct had everything to do with the Speaker. It was about helping him get reelected.
Frias lost to Mattiello by just 85 votes in that 2016 election.
And it's kind of embarrassing to be represented by somebody like him. I don't understand why the Speaker surrounds himself with these kinds of criminals.
Notwithstanding Mr. Frias's position on this, which is an understandable one, and the et al. That goes along with that, I can tell you that under no circumstances will I ever go to sleep at night thinking that Nick Mattiello was unaware of this saga. Impossible. Impossible. And interestingly, the Board of Elections struggled with this case. The Attorney General came to the aid, defense, and support of the Board of Elections through this announcement in a way, which I think is a good thing, because the Board of Elections, first of all, has been a Keystone Cop operation for a long time. Secondly, it's gotten its act together in the last few years, more than less, and it was more or less disrespected during this entire process by the people who were asked to participate, which may have gotten at least one individual jammed up here. Yesterday on the show, I asked Steve Erickson, the vice chairman of the Board of Elections, about the process and whether they actually went to the top on this. The Board of Elections exonerate the Speaker of the House.
Did we exonerate? We made no finding.
Big difference.
We never say somebody didn't do something. We say there's no evidence of this having been done.
You never spoke to the Speaker directly. You never spoke to Mr. Jerzyk directly.
Not only did we...
You never spoke to Checkmate Consulting directly.
Nope, nope, nope.
And I'm wondering if the Attorney General did.
I don't know.
We'll find
you can
out.
Ask him
He's
tomorrow.
coming in tomorrow. Welcome, General.
Hi, Dan.
Great to have you.
Great to have you. Happy to be with you.
notwithstanding my seasoned experience and knowing what I probably will get from you and what I won't get from you, and the efforts by your outstanding staff to encourage me not to ask certain questions. Did you ever talk to the Speaker directly?
Yeah, I can't answer anything about that case and how we investigated it. Let me just say this, that when we go into any case, and this case is pending, and in fairness to the defendant here, I don't want to comment on the case. Once, I feel like it's incumbent on us to be transparent, to announce our charges and what we allege, and allege is the key word there. Once the case is charged, I have an obligation ethically not to talk about it beyond sort of what I've already said. But let me say this generally. I've been doing these cases for a long time. I had my best people on this case, including the criminal chief, Steve Damrook. We know how to do a thorough investigation. We did it here. I'm confident that the charges that we brought were the right ones. It will remain to be seen how the case works out in court.
Remain to be seen how it works out for Mr. Britt, he who is indicted, or others as well?
No, the case that we charged, the case against Mr. Britt.
Yeah. In the press conference, you indicated, and I'm sure you're going to reiterate it here, you don't expect any other charges to come from this case.
No, I don't. Look, the key there, and I was asked this question, is, who had knowledge? I mean, we have to prove, with respect to the allegations, knowledge. That's true in every criminal case. And, when we're doing that, we charge the people, in whether it be this case or any other one, where they have knowledge or where they have the requisite criminal intent. That's what we do. And look, the evidence is what the evidence is. We don't engage in speculation. We can't put speculative evidence on in front of a jury. We can't put it in front of a grand jury. So we pursue the evidence where it takes us. And look, these cases are what they are. And when I say it'll play out, this case will play out in court, and we'll see where it goes.
The Speaker this week on the radio confirmed that he did not appear before the grand jury. Can you talk about who didn't come in front of the grand jury?
I can, because grand jury secrecy rules are such.
But participants can confirm.
They can
confirm that they went in front of the grand jury.
They can. So the way it works is grand jurors, neither the grand jurors nor the stenographer nor the lawyers can never talk about what's in front of a grand jury unless a court authorizes it. Otherwise, it's a crime. Then we can't do that.
By the way, you've been working on legislation that, in rare circumstances,
correct,
you will ask for that, a la the Diocese of Pittsburgh's issue.
Correct.
Correct.
38 Studios might be an example there. Look, I think the case we're going to talk about in a little while, the Wyatt, might be a good instance where that would be helpful. But we don't talk about it. And I'll say this, there are certain instances. Look, we go after the evidence we need to prove what we feel like we need to prove and to investigate what we think we need to investigate.
The statute of limitations was about to come to a halt on Mr. Britt's activity. If I look at the indictment and the dates that the allegations pinpoint to, did you get this thing done under the wire?
Yeah, I think that being truthful, that's right. I mean, we knew we had to move quickly. Part of the problem here is, and I think the Board of Elections really did a really good job here, given the amount of power they have. But when the Board of Elections works on something for 18 months or 2 years, and then it comes to the AG's office in cases where the typical charge, even in this instance, the felony is 3 years, the statute of limitations, that does not give us a lot of time. So we had to move pretty quickly here. And look, these cases,
And by the way, you got the case off the desk. I mean, it came to the former Attorney General's office in September of last year, correct? And so it was in your to-do file.
Yeah, look, as there's a turnover in an office, people are preparing for transition. We picked it up and we did what we needed to do with it. But I think we can do a better job, meaning our office can do a better job working with the Board of Elections to say, look, if you're getting full cooperation, this is ultimately, in the first instance, their work to do. And I respect that. I'm not looking to go after somebody who has made their peace, if you will, with the Board of Elections. What concerned me about this case was that, as you alluded to in your opening, there were a number of people who, when the Board of Elections asked them for cooperation, didn't give it. And the Board of Elections has limited ability to make them do that. And I felt in that instance it was incumbent for us to step in. And then once we step in, we can get, through compulsory process, grand jury subpoenas, information that that the Board of Elections can't get.
I'm pretty certain, because I follow this case every day of its existence. The lack of cooperation was probably for two reasons. One, the credibility of the Board of Elections has not been very high over the course of history. Like I said at the top, I think they've improved. Secondly, there was a nonchalance and a cockiness about the amount of money that was involved in this whole thing that I think caused people to think that this thing would be one of those things that would be case closed once
Yeah.
cooperation wasn't offered. But the Speaker of the House is more or less running around thinking that he's all done with this whole thing. We'll remind you of his remarks this week, and then we'll talk about the Wyatt Detention Center case, which is, in a lot of ways, grabbed the public's attention. It's quite the debate. Stay with us.
I did not know what was going on with that mailer, and after 2 very thorough investigations, there's been no indication from anybody that I knew anything about this. Right. You've got a campaign worker who clearly was trying to impress and ingratiate and come up and say, wow, look what I did for you. I blew this campaign open for you. And I did not know.
Look, I'm not. I know that the buck stops more or less with the facts that we've already discussed, and you're not going to go any further. But I just have to ask a few questions about the case. Does the single indictment indicate that your investigation confirms that Mr. Britt acted exclusively and alone?
No, what the investigation or the indictment concludes is that Mr. Britt had knowledge of certain, as we allege, of certain criminal misconduct and committed certain criminal misconduct. It speaks for itself. I mean, that's why we wrote the indictment the way we did. You know, we chose to do a speaking indictment here, which is meaning lay out the actual allegations, because that is those are the charges that we believe at this point the admissible evidence will prove. Again, they're allegations. He's presumed innocent, and the trial will play out.
It is just, I'm going to lay this out. You can comment if you want to. It is incomprehensible to me to think that Mr. Britt was looking to impress. The Speaker admitted that he hired Mr. Britt away from whoever he was worried about hiring, because this is the kind of guy in politics around here that you don't want working against you, reportedly. And number two, I'll be a monkey's uncle if Jeff Britt handed out cash to somebody in a straw. By the way, I'm not defending the act. I want to be clear on that. I understand what the charge is, and it reads pretty clear to me. My concern is that the Speaker of the House is running around the state going, I know nothing about this whole thing. And it is absolute, and I followed this case in real time, and under no circumstances will I ever believe, based on what I know journalistically, that Mr. Britt acted independently, that the very notion that the mailer itself is, and the content was not written by him, and it was not marketed or put out by him. So there are at least 2 other layers in the organization who, by their protocol, would check with the campaign manager, Mr. Skenyon, and the Speaker, Nick Mediel, before putting it all out. It leaves people who are watching this case wanting.
Yeah,
you understand that?
Of course I do. Look,
not suggesting that you charged wrongfully, suggesting that it's a wanting case.
So you have to look at any incident through a couple of lenses. There's a political lens to this. I get that. The political lens is not my lens. That's not my mission. My mission is to what was referred to us by the Board of Elections. We investigate. What do we find? What evidence do we uncover? What does that evidence mean? Who can we charge based on that evidence? That is my only mission. I have to stick to that mission. I can't call journalists in front of the grand jury.
So it leaves us in the conundrum, and I'll leave it here because, and let me say this. I've said this many times. I was bullish on Mr. Neronha getting elected. I've been a fan and will continue to be one, not because I'm kissing any tail here, but because I think he is the right guy for the job. And I'm always reminded that in these particular cases, we didn't get this kind of cooperation from former attorneys general. And so I will always appreciate that. And you come here and tell me what you can and cannot say. You have my utmost respect for that.
Thank you.
I just don't understand why you can't tell us why, when and if you, or if you did talk to the Speaker of the House about this.
Yeah, because by the rule we cannot.
Because that's not just political, General. That is. It is. I mean my Kmart understanding of the law would be that if there are others who are part of an act, that there's responsibility at the head of an organization for that which a consultant to the organization does.
Sure, but here. The rules prevent us from talking about anything which would indicate
the grand jury
what
rules.
Happened. Yes, before the grand jury.
Yeah.
So we can't provide what the grand jury instructions were. We can't say how many witnesses were called before the grand jury. We can't do it. Now, let me just say this though. Then I've done lots of cases lots of cases against individuals, but some witnesses testified and some didn't. There are instances under the federal rules where you don't call certain witnesses into the grand jury because you can't under the ethical rules. I don't feel like there's ever an instance where I can't get the information I need given the tools that we've got, up to a certain point. I don't hesitate to use whatever process we have. I know how to do one of these investigations. I've done them a long time, and I'm confident that we did this one the best way we
So
could.
my last question, I guess, would be, when I say I don't believe and never will believe that the Speaker was unwitting to this situation, and I'm not trying to prosecute the Speaker. I didn't think this was 55 and a 50 as far as I was concerned, but you know what? That 5 miles an hour can tip an election, and I understand why your interest in this case and your white-collar corruption track record and political corruption track record stands on its own. Doesn't mean I'm headhunting the Speaker. It means I just don't believe it.
Yeah.
So when I say I don't believe it, you say what?
Well, look, I don't do, in this job, I can't engage in speculation. Look, I appreciate your ability to think or believe or go with your gut. I'm in a legal process. Every piece of evidence I put in front of a grand jury, whether it be case A or B or C, has to be something that I can introduce in court later to get a conviction. So I can't put in evidence that's based on they must have known or they had to have known. I can't put in evidence that says, speculate about this or speculate that. It has to be a witness or a document that I can introduce before a jury of one's peers to try to prove an element of a crime. That's the only way you can look at these cases.
And I'm guessing you got all the documents you need from the Brit side of this thing to cause the indictment.
Well, look, we don't ever charge a case where we don't think we can prove it. Now, that doesn't mean we will prove it. I've lost cases personally, and we've lost some in offices that I've led. But I don't go to a grand jury and seeking an indictment, giving a grand jury the option to return an indictment unless I think they reasonably could return an indictment, and it's a case I'm prepared to prove.
All right. You can't tell me whether Britt was in front of the grand jury, though.
I can't tell you anything
me,
about
you
it.
can't.
Anybody who goes before the grand jury can talk about what happened there.
Right.
The lawyers and the grand jurors cannot by law.
Fascinating case out of the Wyatt next.
It's been 2 months since this pickup truck, driven by Captain Thomas Woodworth, drove through protesters outside the Wyatt Detention Center. Jackie Alexander was sitting on the ground and says she was hit.
I have physical injuries, but the emotional injuries are worse.
Tammy Brown was also there. She says she was pepper sprayed by correctional officers who emerged from the Wyatt.
The idea that prison guards can come out of a prison and run people over and pepper spray them is absolutely outrageous to me.
The August 14th incident prompted an investigation by the Attorney General's office, which convened a grand jury. Those jurors this morning decided not to charge Woodworth or any of the guards who deployed pepper spray.
Prosecutors are not present for a grand jury's deliberations, nor does a grand jury share its reasoning with prosecutors.
Attorney General Peter Neronha would not give his opinion on whether any of the correctional officers committed crimes, respecting the decision of the grand jury, which meets and deliberates in secret.
If 20 years of doing this, I've never once criticized a jury, and I've never once criticized a grand jury, and I won't do it.
None of us felt that a good job was done by the grand jury at all. For example, they did not ask me once about the conversation I had with the man who hit me with his truck and all but ruined my life.
I am fearful now that it gives people carte blanche to just attack us and pepper spray us every time they don't agree with what we do.
Which is, can I say this? Asinine. That is an asinine comment. And she's not the only one to have made it. Aaron Regenberg, who almost became a lieutenant governor, said worse yesterday. I'm going to leave the audio where it is for now here. Fascinating case in so many ways. I said yesterday on the air, on the radio, that it was kind of like an NFL referee who goes under the tunnel, goes under the hood and looks at the videos, comes back and says the ruling on the field is confirmed, because there were no charges issued at the event. I don't mean to downplay the seriousness of the case. I'm just saying it felt that way because it seems like there's a lot of video that was looked at. Yes, some 70 different videos.
Yeah, there was a lot of evidence.
People's phones, I'm guessing.
Yeah, so some of it was social media, some of it was the news footage from news outlets, some of it was from the facility itself that we wanted to pull. So someone asked that yesterday, why not just do charges in the beginning and then sort of go a different route? Well, if charges had been filed that night by, say, the Central Falls Police Department or the State Police, it would have come to my office to go either through the information charging process, not to get into the weeds, or the grand jury. The grand jury...
You love the grand jury process.
I do. I mean, you can't...
It's an investigative tool. You've said that.
Yeah. Look, the federal system, every case is charged to the grand jury, so this is sort of weird, in a sense, you know, narrative that, well, why use a grand jury? Well, grand jury we use in every single case in the federal system. We don't do it in every single case in the state system because the volume is too high. But even then, that required a constitutional change in the 70s. The grand jury is a great opportunity to get all the evidence. If we need medical records and we need to get a subpoena to get them, we get them. If we can't get footage that we think is relevant, we can use a grand jury subpoena to get it. We put witnesses in front of the grand jury to evaluate their testimony. And there was a lot of testimony to evaluate here. So, look, I get the disappointment on the part of the protesters. Protesters were there, they were peaceful, they blocked an access point, they could have been arrested. Law enforcement gave them a pass that night. That was a decision law enforcement made.
And you supported them with your comments yesterday, suggesting that they were never of interest here in this case, and that nobody made, I'd have to paraphrase, there were bad decisions made, but you excluded the protesters from that.
Sure, because
respectfully, is that the nurturing political side of you in this particular case?
Here's why. The protesters went there and blocked that access point knowing that they could be arrested. Many of them expected to be arrested. As soon as law enforcement decided on that night not to arrest them, at that point, to me, what I meant by that was, I'm not going to charge them now, 2 months later, for conduct on which they got a pass on the night in question. The decisions I made, that I believe that were made wrongly, were this. There was insufficient law enforcement presence on the scene at the time. If there had been law enforcement presence there that was robust enough to keep this driver away from that group, none of this would have happened. And of course, the decision by the driver to make that turn, those are the decisions that caused that incident that night. As we look back on it, what's our lesson in law enforcement? And I look, I have a role in this. I advise law enforcement, have enough of a police presence present for a protest so that you can keep these sort of individuals apart. If there's a police officer there that night that says to the guy coming down the street, go park over there, none of this happens. But it happened. We have to move on from it, learning our lessons.
All right. Someday we'll do a whole practicum lesson on the grand jury, because I think it's something that people are pretty unwitting to in terms of how the whole thing works. We all could use a brush up on the whole situation, especially since you have a fondness for that avenue in terms of prosecution.
It's a great investigatory tool.
No judgment, though, on the correctional officer from you, right? In terms of whether he should be employed again or the like?
No, I mean, that's not my decision to make. I think he made a very poor decision that night, very poor decision to turn into that group. You know, the grand jurors are the ones, though, ultimately charged with judging his conduct. And look, you know, sometimes jurors, in my experience, have trouble with the distinction between criminal misconduct and mere misconduct. And that may be what drove the decision here, but I don't know. I wasn't there for it.
I appreciate you dialoguing on these cases. Just appreciate it.
Thanks, Dan. Good to be here.
Final word, we come back. Lots of focus on education next week, the RICAST numbers and the comparisons. Again, the junior varsity game that we play here in the state, where the suburban towns, dominate the urban towns, and they think, hey, we won the league. That's winning the JV, unfortunately, in education here in Rhode Island. Comparing comparable towns from Rhode Island to Massachusetts is another story. And at least this commissioner is trying to bring that theme home here. More on that next week as we peruse the all-important RICAST numbers. Have a great weekend. Thanks for tuning in. Good night.